This program is brought to you by the Reeves Law Firm, www.reevesfirm.com.
In the know.
Good evening, everyone.
In the know. Tony Reeves. Tony Reeves. Tony Reeves. Tony Reeves. Fire. Following the news in any way, shape, or form. No shortage of things to talk about. What does it mean? What will it bring? Is this a reality we simply have to accept? Tony Reeves. Fire. Tony Reeves. Let's go ahead and get started.
What's the best way to talk to an attorney? Or how can I engage an attorney? Okay, first of all, let me start by saying that if I say anything that comes off as condescending or disrespectful, it is not my intent. But let me kind of explain to you, because one of my colleagues made a very interesting point to me the other day where she said, part of the problem that people have with dealing with attorneys is that they don't really understand what we do and how we do things, and more importantly, how we process information when we're trying to figure out how to represent someone. So I want to give you a little bit of insight that may help you out. First of all, let me just be blunt when I say this. This is not applicable for all people. Everybody has their own personalities. You're going to find some representatives and attorneys that are really nice regardless, and then there's going to be some that are jerks. So there's just really nothing you can do about it. But here's a couple of things that you need to keep in your mind. A lot of times when people are going to an attorney, they're not thinking about it from what's the best way to get the best response from that attorney. So I tell people, you have to think of it like this. What you think is important for that attorney to know, as opposed to what that attorney wants, are two totally different things, because the way they're dealing with the questions you present is how they respond. Here's the thing that you need to understand. Attorneys are trained to recognize that the law exists, but that every scenario that those facts apply to are on a fact-specific basis. So in essence, every legal issue that you deal with, whether it be family law, criminal law, tax law, civil litigation, criminal litigation, all focuses on one fundamental question. Once you lay out that one fundamental question, then under that's like the umbrella, then everything else filters down. Now, you're going to say, okay, so what is that saying? Well, what that says is this. Most attorneys are trained to process information based on what is the overarching question. Once you give them the overarching question, then they can determine what particular information they need from you in order to answer your question and provide services to you. Now, that's how attorneys work. So what does that mean? That means almost most times, if you know you have a question for an attorney, start with the question. What happens is, and this is not trying to be disrespectful, so don't take this the wrong way. Most people want to brain dump because they have so many facts that they believe that the attorney needs to know about. They feel like, let me dump all of this on the attorney, and then the attorney will be able to sift through and pull out the pieces of information that they need in order to determine whether they can help me. That is just not the way it works. Because here's a couple of things you have to realize. One, they don't know what your question is. So you're basically giving them, it's like getting on the road and driving somewhere with no destination. They don't know where you're going. So what's happening is that you're giving them all this information and you're expecting them to retain this information and be able to go back and look through later as to what's relevant. And I always tell people that's the most backwards way for dealing with attorneys, because we're not trained that way. We're trained to give us the problem, then we can determine for you what's the best outcome based on the facts you provide us. Now, let me tell you what people tend to get frustrated. A lot of times people tell themselves that, well, if I give you all this information to begin with, right out the gate, then you'll know this ahead of time, then you won't need to ask me all these questions later. I said, the problem with that analysis is you're doing it based on what you think is important, not what the attorney thinks is important. The attorney is focusing on the law. They understand the law and how everything flows from it. You're focusing on the facts, your facts, and you believe that all of your facts are relevant. Some facts may not be relevant. So this is the other thing that you also keep in mind, especially if you're dealing with someone who's thinking about taking your case. You're not going to get their attention throwing 100 pounds of facts at them and hoping that they'll be able to pull out a case out of that. That's not the way it works. So what's the best way to do? Well, It's amazing because people get frustrated. And I've seen this a countless times when I'm like, what's your question? Because what's happened is two things pop into place. One, you believe that the question that you ask will be simple in nature, and it may not totally encapsulate everything that you need to bring to that person's attention. But what's happened is that you're thinking on behalf of the attorney. You're thinking the attorney won't ask those extra questions. Give that attorney the opportunity to ask those questions. Trust me, they're going to ask those questions if you give them a basis for it. So that's the first thing. Okay. The second thing is you feel that if you give all the information initially, then the attorney can take the bulk of their time giving you their legal advice without having to ask you all these questions. But again, you're thinking about it from a brain dump situation. Remember, you maintain this reservoir of information and facts regarding your case on a regular basis. So you're in the best position to regurgitate that information as quickly as possible. You're thinking, I just want to get it out there one time. And here's the other thing that I understand. Most times when you get an attorney that's willing to listen to what you're saying, you feel like this is your shot. You got to get it all out there. I know this sounds crazy. Focus on the question. You'll be surprised how many attorneys will be appreciative if you just start off. If your biggest question is that, and sometimes this is where it gets troubling. The troubling part for some people is that they don't really know how to ask the question because they think that the question is simple. Let's use an example of like statutory rape. If let's say that the ultimate question is, like somebody will say, I had sex with the young lady I met in the club. Do I need to be concerned? Now, an attorney is going to give you a look and say, okay, nobody normally asks that question unless something happens. Did the person yell gang or did the person yell rape? Did you use a roofie? Was the person underage? What? What happens is that most people, when they ask questions, they ask a simplified question, not including those facts. But you can ask a detailed question that includes those facts. So what would be a more appropriate question? A person comes to you and says that individual had sex with an individual they met at a club, and they found out after they had sex with the person that they were 15 years of age, 13, whatever it was. The person got into a club using a fake ID, and so you were under the belief, the person was under the belief that everybody in the club was under the age of 21. They had no idea that this person had used a fake ID, and they were not under the age of 20. They were under the age of 21. Should they be concerned from a criminal standpoint? That is a detailed question that lets the attorney know we got a couple of issues. You've got a person who came in the club under a fake ID. They represented that they were 21. You met that person and you treated that person like they were 21 because they came into an establishment that only recognizes individuals that they're 21. You didn't check for ID. You had no reason to believe it, and you're wondering what's your problems. Well, then that attorney can tell you based on the law what issues you're going to face. But a lot of times people don't do that. They don't want to go to the question because they believe that by going straight to the question that they are omitting key facts that might change the attorney's mind. But this is the problem that I tell people. If the attorney genuinely wants to know more information in order to change their mind, they're going to ask you. But then here's a way that you can solve that problem. Let's say that the attorney says, sucks to be you, that's statutory rape. Sorry. Now in your mind, you're thinking that one sentence is all they gave me. I got all these different other facts. Well, here's an easy way to do that. Just come back and say, listen, is there any additional information that I could provide to you in terms of fact that might change your position? See how simple that was? And that's what somebody's saying, you're being condescending. I said, no, I'm not. I'm really telling you. Because what happens is that people find it upon themselves that they want to get all that information out. And I tell them, you'd be surprised. Now, by doing it like that, guess what's happened now? You've now given the person who has evaluated your case the option of deciding if they need more information. If they tell you they don't need more information, do not waste your breath trying to convince them. Because they basically told you with the information that you've given them, they don't want any more information. So don't try to force feed them to convince them to take your case. Move on to the next representative. It's just that simple. I know this can be frustrating because I always tell people nobody really wants to come and deal with an attorney, period. I got that. But I want you to make sure that even when you have an attorney, if you come and you present information like this, it makes it so much easier for them to ascertain how to best answer your question in light of the law and the facts you provided to them, and it gives them the ability to give you the answer in the most clear and concise manner. Tune in next week as we talk about consultative examinations here on Q&A, Social Security and Disability Today.